Friends, good afternoon. In this video, we will explore Article 136 of the Constitution of India, which talks about extraordinary power to listen cases even directly from the tribunals. Friends, it is well settled that Article 136 of the Constitution does not confer a right to appeal on any party. It confers a discretionary power on the Supreme Court to interfere in suitable cases. Article 136 cannot be read as conferring a right on anyone to prefer an appeal to this court. It only confers a right on the party to file an application seeking leave to appeal and a discretion on the court to grant or not to grant such leave in its freedom. When no law confers a statutory right to appeal on a party, Article 136 cannot be called in aid to spell out such a right. The Supreme Court would not, under Article 136, constitute itself into a tribunal or court just settling disputes and reduce itself to a mere court of error. The power under Article 136 is an extraordinary power to be exercised in rarer and exceptional cases and on a well-known principles. Honorable Supreme Court, in the case of Ashok Nagar Welfare Association versus R.K. Sharma, AAIR 2002 SC, page 335, considered the issue of filing of SLP against all kinds of orders without realizing the scope of Article 136 and held that even in cases where special leave is granted, the discretionary power vested in the court continues to remain with the court even at the stage when the appeal comes up for hearing. Nowadays, it has become a practice of filing SLP against all kinds of orders of the High Court or other authorities without realizing the scope of Article 136. Hence, we feel it incumbent on us to reiterate that Article 136 was never meant to be an ordinary form of appeal at all, like Section 96 or even Section 100 CPC. Under the constitutional scheme, ordinarily, the last court in the country in ordinary cases was meant to be High Court. The Honorable Supreme Court, as the apex court in the country, was meant to deal with important issues like constitutional questions, questions of law of general importance, or where grave injustice has been done. If the Supreme Court entertains all and sundry kinds of cases, it will soon be flooded with a huge number of backlog and will not be able to deal with important questions relating to the Constitution or the law or where grave injustice has been done, for which it was really meant under the constitutional scheme. After all, the Supreme Court has limited time at its disposal and it cannot be expected to hear every kind of dispute. Thus, under Article 136 of the Constitution, the Supreme Court generally grants special leave to appeal only in the cases shocking its conscience. As such, the matter must indicate some shocking feature for invocation of such power. So, this is the Honorable Supreme Court's view that how Article 136 is misutilized by most of the people when these things can be solved at the High Court level. That's all. God bless you all.